Good evening. My name is Kitona Ogletree, and I am presenting to you the case of Ricci versus DiStefano. I will narrate the case and go over my case briefing. I will also go over the additional questions that was posted via this teacher at the end. And in the end of this oral presentation, I will conclude it with my final thoughts. So let's begin. This case is Frank Ricci versus John Stefano. This case was decided in June of 2009. The pretty much main facts of the case is that the white and Hispanic firefighters brought a lawsuit against the city of New Haven, Connecticut for violating the Civil Rights Act of 1964. Prior to this particular case, the black firefighters brought a lawsuit against the city of New Haven for allowing the test that they take in order to determine whether they're qualified to become a lieutenant and a captain. What they felt that this test was very biased and that it did not state, just because of the written portion they did not do so well in, that if a field test was also included in this test, that they would have done excelled in that one, because it's not all about the written, it's also about the field, because this is a very demanding and dangerous job. So therefore it should not all be about book smarts, because some people are smarter hands-on, and then other people are smarter both, and some are just smarter in the books only. So therefore they brought the lawsuit first, and then because the city of New Haven sided with the black firefighters, they discarded the test. So the Hispanic and white firefighters felt that this was not fair, because they scored high and would have been promoted with this test had they kept it. But because they discarded it, now it's now wondering how exactly people are going to go about getting hired for the different positions. And they, all these years they went with the test, and now they're just all of a sudden deciding to discard it, even though this test doesn't come about very often. So the city of New Haven, the Supreme Court decided that the firefighters, the white and Hispanic ones, had a legitimate case. So they went ahead and upheld the initial ruling of that the black firefighters were right. So then the Supreme Court decided to reverse it, and decided that the test should be admissible, and that the test should have helped to determine who would be the best candidates for the job. So this pretty much says that when they're going to go and do this job, that once you learn all the field work, that it takes more than just learning the field work. You should also know all the legal terms and all of the different terminologies, as well as just knowing how to go out there and fight a fire. So when you first get hired for this job, you don't really get told all of that information. So people are more trying to be the best firefighter they can be, and not worrying about the book aspect of the job. So therefore, studying is not exactly the easiest thing in the world with such a demand of a job. So I feel, based off the first question that was posed, did the case involve disparate treatment and disparate impact, or both? I would have to say it involved both. And the reason why I would state that is because in the disparate impact statute, a plaintiff establishes a prima facie violation by showing that an employer uses a particular employment practice that causes a disparate impact on the basis of race, color, national origin, and so on and so forth. So the second question asks you whether you agree with the Supreme Court's ruling. I don't personally agree with the Supreme Court's ruling. I believe that you should be tested on both your book knowledge, because you should learn the different terminologies, as well as the field knowledge. I feel like the field knowledge should be more important than the book knowledge, because if you can do the job and do the job really well, a person could be smart and a bookworm but not know how to do the field, and therefore get promoted to such a high ranking position with only knowing how to pass a test on knowledge of a book. So I don't really agree with that Supreme Court ruling, and I believe that they should have a field test plus the book test and combine the two scores and hire accordingly. So that is my opinion on the Supreme Court ruling, and I feel like it should be a 50-50, 50 the test written and 50 the field test. And so that is my opinion on this particular case, and I thank you for hearing my case today. Have a good evening.